Hello and a very happy new year to all of you. I am Taniya Pandey and I welcome you to our latest episode of Courts This Week on LiveLaw. If you're new here, do subscribe to LiveLaw to not miss any legal updates that we bring every week from courts across India. As usual, let's begin the episode with judgments from the Supreme Court. The central government has told the Supreme Court in an affidavit that it has decided to accept the recommendation made by an expert committee to retain the limit of Rs 8 lakhs gross annual income for economically weaker sections reservations. The centre has also accepted the recommendation to omit the residential asset criteria for EWS eligibility. However, the ongoing admissions, including the NEET PG counselling, will proceed as per the existing criteria, and the revised criteria will be applied from the next academic year, the centre further said. The affidavit has been filed in response to a writ petition challenging the centre's decision to introduce economically weaker section or other backward classes reservation in the All India quota for NEET. The Supreme Court has further clarified its December 2019 order by which it lifted the status quo as regards construction, industrial activities and felling of trees in the Taj Trapezium zone, insofar as the order required concurrence with the Central Empowerment Committee and opinion of the National Environmental Engineering Research Institute. The top court on March 22, 2018 had ordered status quo regarding grant of environmental clearances to various projects by the authorities in the zone till the time the vision document on protection and preservation of the Taj Mahal and the surrounding environment was filed by the Uttar Pradesh government. The court further made it clear that the embargo on granting clearances for shifting of any heavy industry shall continue till a final decision is taken on the vision document. The Supreme Court has affirmed that there cannot be two different pay scales for the employee appointed on compassionate ground and the employee appointed on a regular basis, and that the moment a person is appointed on a particular post, that person is entitled to the pay scale of the very post, even if he was appointed on a compassionate basis. The bench of Justices M.R. Shah and B.V. Nagaratna was hearing State of UP's SLP against a decision of the Allahabad High Court, where the High Court had allowed the respondent's writ petition directing the state authorities to pay on the pay scale which was available for the post of officer on special duty. The Supreme Court has observed that the money that is deposited by the customer in the bank is not held by it as a trustee, but it becomes a part of the banker's fund, who is under a contractual obligation to pay the sum deposited by a customer to him on demand with the agreed rate of interest. A bench of Chief Justice of India N.V. Ramana, Justice Suryakant and Justice Hima Kohli made this observation while dealing with an appeal of a former bank manager who was convicted for offences relating to criminal breach of trust, cheating and falsification of accounts under the Indian Penal Code. The central government has approached the Supreme Court seeking recall or modification of the top court's order dated December 17th, by which it had stayed the election process in the seats reserved for other backward classes in the local body elections in Madhya Pradesh, relief for deferring local body election for a period of 4 months, with a mandate to the state government to come out with the Commission's report and directing the State Election Commission to hold the elections accordingly, has also been sought. In the December 17, 2021 order, the bench of Justices A.M. Khanvilkar and C.T. Ravi Kumar, along with staying the elections for OBC, had also directed the Election Commission to re-notify the seats for general category. Let us now go over judgments from the High Courts and other courts in the country. The Madras High Court, while following up on a set of measures to be taken for the protection of the LGBTQIA+ community, has directed the Union Government to extend the scope of Garima Greh scheme to all members of the community and not just transgenders. A single judge bench of Justice N. Anand Venkatesh made this direction while perusing a status report filed by the Ministry of Social Justice and Empowerment pursuant to a slew of guidelines given in a judgment dated 7th June to ensure the protection of LGBTQIA+ persons in consensual relationships from police harassment. The Calcutta High Court on 23rd December directed the State Election Commission to preserve CCTV footage of all polling stations of Kolkata Municipal Corporation elections held on December 19, 2021. The State Election Commission was also directed to preserve the diaries of the presiding officer and register containing the thumb impressions or signature of voters of all the polling booths in a sealed cover with immediate effect. A bench of Chief Justice Prakash Srivastava and Justice Rajarshi Bhardwaj was adjudicating upon a batch of petitions which had alleged that deployment of central forces is required for remaining municipal polls, considering the large-scale violence that took place during the Kolkata municipal elections. The Gujarat High Court has observed that as per Muslim law, a husband has not been given any fundamental right to compel his wife to share his consortium with another woman in all circumstances. The bench of Justices J.B. Pardiwala and Niral Mishra made this observation while holding that in a suit filed by the husband for restitution of conjugal rights, a woman cannot be forced to cohabit with her husband, even by way of a court's decree. In this case, the court was dealing with the wife's challenge to the decision of the family court that had directed her to go back to her matrimonial home and perform conjugal obligations. The High Court referred to the object behind Order 21, Rule 32, Sub-Rules 1 and 3 CPC, and overturned the family court's order, holding that no person can force a female or his wife to cohabit and establish conjugal rights. The Karnataka High Court has said that if the Karnataka Housing Board has not obtained previous or prior approval from the state government before execution of the sale deed, it would invalidate and vitiate the said document. A single-judge bench of Justice S.R. Krishnakumar quashed the sale deed executed by the father of the petitioner with the board on August 23, 2006. The court declared the sale deed executed by the petitioner's father in favour of the board to be null and void and directed that it be cancelled. Dissatisfied with the initial report filed by Superintendent, Presidency Correctional Home, West Bengal, in the case of a missing under trial, the Calcutta High Court has directed the authorities to trace the man and present a further report in the matter. Essentially, the bench of Justices Shampa Sarkar and Vibhas Ranjan De was hearing a habeas corpus petition filed by one Buddhadev Bhaumik, alleging that his father, an accused in a criminal case, went missing from the Presidency Correctional Home just before he was scheduled to be released on bail under the court's order. The Competition Commission of India on 31st December 2021 directed investigation into Apple's App Store policies with respect to allegations of unfair trade practices in India raised by a non-governmental organization, Together We Fight Society. The informant alleged that Apple uses a barrage of anti-competitive restraints and abuse of dominant practices in markets for distribution of applications for users of smartphone and tablets and processing of consumers' payments for digital content used within the iOS mobile application. The Commission has further directed the Director General to investigate the matter under Section 26 of the Competition Act and complete the investigation and submit the report within a period of 60 days. While declaring a couple as legal and biological parents of a child born out of a surrogacy arrangement, a Delhi court has observed that there is no law in the country which bars parties from entering into gestational agreements. Civil Judge Chitranshi Arora of the Saket Court analysed the law regarding surrogacy in India and observed that while there is no statute which governs surrogacy in the country, the guidelines issued by the ICMR do regulate surrogacy arrangements in India. The court was of the opinion that the plaintiff couple was entitled to a decree under the provision of Order 12, Rule 6 CPC, and also restrained the defendants from acting in contravention to the terms of the gestational surrogacy agreement. That is all for today. Thank you for joining us. I am Taniya Pandey and you are watching Courts This Week on LiveLaw. I hope you have a brilliant year ahead and that 2022 proves to be better for you in every aspect of your life. Take good care and I'll see you very soon.
Subscribe to our channel and press the bell icon to never miss a video from LiveLaw.